Two men climbed into a lifeboat on a New York pier. The boat was dry. It was the 28th of September, 1912. The Titanic had been on the bottom of the Atlantic for 5 months. The boat had crossed that same ocean stacked on the deck of another ship, with 12 more like it. The two men were Frank Martin and Henry Masters. They were not investigators. They were appraisers. They counted the boats, they noted the damage, then they wrote down what the boats were worth. $5,700 if they had been sound, minus $1,180 to put them right. $4,520. That figure did not go into a salvage file. It went into a court document. Because the company that owned the Titanic was about to walk into a federal courtroom and state, in writing, the full extent of what it believed it owed. 1,517 people had died. White Star had a figure ready. It had had one since October. The story everybody knows ends with a door in the water. This one ends with a filing cabinet. The Titanic was built in Belfast by Harland and Wolff. The arrangement between the yard and the shipping line was not a contract in any way anybody would recognize. There was no fixed price. The yard billed every pound it actually spent and added its profit on top of the total. Senator William Alden Smith put that to Bruce Ismay, the head of the line, under oath in Washington. His question was simple. Was there any limit of cost placed on the contractors who built the ship?
No, sir. We have never built a ship with Harland and Wolff by contract at all.
So the yard could not lose money on the Titanic. The more she cost, the bigger the check. She cost £1.5 million, about $7.5 million at $5 to the pound. That figure did not come from a historian. White Star's own officers gave it to the Senate, under oath. 8 men died building her. 15-year-old Samuel Scott, a catchboy on a riveting squad, fell from a ladder inside the hull in 1910 and became the first person the Titanic killed 2 years before she sailed. The yard paid out for every death and every injury on that program. The total came to £4,849, 3 shillings and 5 pence. Hold that number for 1 minute. On the 9th of January 1912, the brokers at Willis Faber walked the Titanic's hull around the insurance market in London. The cover came to £1 million. They cut the risk into pieces and spread it across roughly 70 underwriters, in slices running up to £75,000. The premium for the whole year was 15 shillings for every £100 insured. £7,500, 0.75%. That is the rate you get when everybody in the room agrees that nothing can happen. Insuring the hull for 1 year cost more than the yard paid out for every man killed or crippled building her and her sister combined. One firm turned the risk down. British Dominion's Marine looked at the plans and decided she sat too low in the water. The right answer arrived at for entirely the wrong reason. And there is one more line in that policy worth reading, because the retellings usually get it backwards. The ship cost £1.5 million. She was insured for $1 million. Her owners carried the missing $500,000 themselves, not a trick and not a premonition. Franklin told the Senate the balance sat with the company itself under its own underwriting scheme. Then, at 2:20 in the morning on the 15th of April, the ship went down by the head and the whole arrangement was tested at once. The market paid the full £1 million inside 30 days. Lloyd's puts that number in its own official history. 30 days for the metal. The claims from the people on board took 4 years. Most of them ended with nothing from the company at all. Start with the crew, because their side of the ledger closed first. Under the Merchant Shipping Act of 1894, a seaman was paid until his service ended, and service ended, in the words of the Act, by reason of wreck or loss of the ship, not when he was pulled out of the water, when the ship stopped existing. At the British Inquiry, a fireman named Robert Pusey described lifeboat number 1 at around 3 in the morning. The Titanic was gone. Somebody in the boat said out loud that their pay had stopped the moment she became a wreck. Whoever said it was right. The pay books were closed on the 15th of April, counted by the day. The men in the water were, on paper, off the clock. This was not White Star being cruel. It was the law of the whole trade, and every line in Britain worked the same way, which is arguably worse. The wages underneath that law were small to begin with. A fireman shoveling coal earned £6 a month. A trimmer hauling that coal to the furnace doors, £5.10. A steward took home less than £1 a week. The captain, £105 a month. 12 pence to the shilling, 20 shillings to the pound. A fireman's entire month was 6 of those pounds. Keep that scale, because the numbers get smaller from here. The day before she sailed, William Murdoch was demoted. He had been chief officer at £25 a month. He sailed as first officer at £17.10. He lost £7.10 a month and gained the watch that met the iceberg. The Board of Trade record of what the company owed him on the 15th of April reads, £3 10 shillings. Somebody worked that out to the shilling. Then there is the band. The 8 musicians were not White Star employees at all, and that single fact decided everything their families would get. They were supplied by a Liverpool agency, C.W. and F.N. Black, which had a near monopoly on putting orchestras aboard British liners. The agency had just cut their pay, £6 to £10 a month, down to £4. It cancelled the 10-shilling uniform allowance. Then it charged them for their own sheet music. And they did not travel as crew. They crossed the Atlantic on a single second-class ticket, number 250654. One ticket, 8 men. From that March, every band the agency put aboard sailed the same way. Second-class passengers, contractually required to work every night of the crossing. The reason was not a shilling saved on a registration fee, whatever the internet says. Ismay admitted the change came after the musicians' union complained about them being signed on as crew. The saving was a side effect. The side effect was the part that mattered, because a passenger is not a workman, and the Workmen's Compensation Act protects workmen. Jock Hume, second violin, 21 years old, from Dumfries. After the sinking, his father Andrew opened a letter from the agency. It was an invoice, 5 shillings and 4 pence, for the uniform his son had drowned in. It came inside a total account of 14 shillings and 7 pence. Andrew Hume refused to pay. He forwarded the bill to the Amalgamated Musicians Union, which printed it in the union bulletin and added a single line of commentary.
Comment would be superfluous.
Meanwhile, the public did what the public does. It gave money. The Lord Mayor of London's fund raised over £413,000. Then it had to decide who got it. It decided by rank, 7 grades, A through G, sorted by what the dead man had done for a living. A widow in Class A, married to an officer or an engineer, received £2 a week, and 7 and 6 for each child. A widow in Class G, married to a fireman or a junior steward, received 12 shillings and 6 pence, and 2 and 6 for each child. The ocean had not sorted anybody. The paperwork did, and the paperwork kept doing it for a very long time. The Titanic Relief Fund paid out for 47 years and closed in 1959. The charity outlived the company. From White Star itself, the families of the dead crew got nothing. Not as a scandal, as a contract. The voyage had ended, so the engagement had ended. What crew families could claim came from the statute, not the contract. The Workmen's Compensation Act capped at £300, a duty Parliament imposed, not a decision the company made. Surviving crew, after their union pushed, were granted a bonus in the paybooks. 13 days. 9 days after the sinking, the firemen aboard the Olympic looked at the number of lifeboats on their own ship and refused to sail. They were found guilty of mutiny and let go without punishment, which tells you how badly everyone wanted that verdict enforced. But all of that is charity, statute, and custom. None of it is the company answering for the dead. That question had a courtroom waiting in New York. In October 1912, the Oceanic Steam Navigation Company filed a petition in the federal court for the Southern District of New York. Oceanic Steam Navigation was the legal name of the White Star Line. It was not a defense. It was an arithmetic exercise. So what was left of the Titanic? 14 lifeboats. That is not a figure of speech. It is a legal answer, and it comes from a law written for wooden sailing ships in 1851. The Limitation of Liability Act capped a shipowner's liability at one thing. The words are still on the page.
The value of the interest of such owner in such vessel and her freight then pending.
It was written so that a captain could wreck a schooner on the far side of the world without costing his owner the house. In 1851, that meant a hulk on a sandbar somebody could tow off and sell. In 1912, it was pointed at the largest moving object ever built. And the largest moving object ever built was 2 miles under the North Atlantic. 13 wooden boats came into New York on the deck of the Carpathia in April. The 14th, a collapsible, was still adrift in May when another White Star ship, the Oceanic, came across her. The boat reached the pier a month late and in time to be counted, which is why Frank Martin and Henry Masters spent the 28th of September on a pier with a clipboard. They filed their valuation on the 3rd of October. Then the company added up everything it admitted owing for the most famous night in the history of civilian shipping. The total came to $91,805.54. That is the whole number. For 700 survivors and 1,517 dead. 3 lines make up that total. $4,520, the lifeboats. $2,073.13, cargo. And $85,212.41. Passage money. Passage money is the fares, the tickets, the money handed over at Southampton and Cherbourg and Queenstown to be on board. 93% of what the owners admitted owing for that night was money the passengers had already handed them at the gangway. Against that figure, the claims arrived. By January 1913, there were 279 of them, totaling over $10 million. Claimants had until the 15th of April, 1 year to the night, to file. By that deadline, the total stood at $16,604,731.63. Supplemental claims added another $320,000. Some of them are worth naming. Charlotte Cardeza, first class, claimed $177,352.75. 14 trunks, 4 bags, 3 crates, 841 items. One passenger's luggage claim was nearly twice what the company said it owed for everybody on board. Renee Harris, whose husband Henry produced Broadway shows, claimed $1 million for his life. It was the largest single claim filed. Anna Sjoblom, third class, was 18 years old the day the ship went down. It was her birthday. She claimed $6,200. $16.5 million asked. $91,000 admitted. But that cap only worked if an American law could be pointed at a British ship that sank in international waters. And a man named William Mellor had already stood up in court to say that it could not. There was a second ceiling. British law had one too, but it was set by the size of the ship, not by what was left of her. 15 pounds for every ton she measured. For the Titanic that ran to hundreds of thousands of pounds, against $91,000 in New York. Which is why William Mellor stood up in an American court and argued that America had no business hearing the case at all. The Titanic was registered in Liverpool. She flew a British flag. She sank outside anybody's territorial waters. The flag itself was a tax arrangement. White Star was owned by the International Mercantile Marine, the shipping trust assembled by J.P. Morgan. An American trust, an American board, American money. And a British flag, because United States law only allowed the American flag on ships built in American yards. The largest asset in Morgan's fleet sailed under somebody else's flag for her entire life, for registry reasons nobody on board ever thought about. The Supreme Court of the United States heard the argument on the 13th and 14th of January, 1914, and ruled on the 25th of May. Oceanic Steam Navigation Company against Mellor. Oliver Wendell Holmes wrote the opinion. A foreign ship owner, the court held, may come into an American court to limit its liability, and when it does, American law applies. The court never said the American ceiling was cheaper. It did not have to. Meanwhile, in London, a farmer was winning. Thomas Ryan's son Patrick had been a third-class passenger. Ryan sued in London, and the Royal Courts of Justice took 4 claims as test cases and heard them from the 20th to the 26th of June, 1913. The jury was asked 2 questions, and it split them.
On the lookout, no negligence. On the speed, negligence.
She had been driven at close to full speed through a stretch of ocean she had been warned about, and the ice message from the Mesaba never reached the officer who needed it. The award was £100 per claimant. White Star appealed to the Court of Appeal in November 1913. It lost. It appealed again to the House of Lords in February 1914. The appeal was dismissed, and the finding of negligence stood. The largest shipping combine on earth took a farmer all the way to the House of Lords, over £100, and lost twice. One night, 2 countries. In London, a jury, and then the Lords, said the company had been negligent. In New York, the same company was arguing that everything it owed would fit in the cost of 14 damaged lifeboats. Both of those things are true. So which one was the company going to pay against? By the summer of 1915, the American case had ground on for 3 years, and the claimants were tired. Their committee negotiated. 44 of the 60-odd law firms came to terms. The figure they were pressing for had fallen to $2.5 million. In December 1915, White Star agreed to settle for $664,000. $500,000 to the American claimants, $50,000 to the British ones, and $114,000 that never reached a family at all. Interest and legal costs. Against the $16.5 million claimed, that is, 4 cents on the dollar. $550,000 of it reached the families. Renee Harris asked $1 million for her husband and received $50,000. It was the most the company paid for any single life. Charlotte Cardeza's wardrobe claim was 3.5 times what the company paid for Henry Harris's life. In exchange, every claimant dropped every action in both countries. They signed a form of words accepting that the disaster had happened without the privity or knowledge of the owners, which in law means one thing. The men at the top did not know and could not have known. The checks went out. The case looked finished. It was not finished. There was still a decree to sign. On the 28th of July, 1916, Judge Julius M. Mayer signed the final decree in the matter of the Oceanic Steam Navigation Company. It found that the sinking had happened without the privity or knowledge of the owners, and that the company was not liable to any extent.
Not liable to any extent.
Read the dates in order. White Star paid in December. In July, the court ruled it had never owed a cent. Every dollar the company paid an American family for the Titanic was, in the end, a gift. Not a judgment, not damages, not compensation. A commercial decision to end a case that had already run 3 years and more than 60 law firms. There was no moment when the ledger balanced. The market paid for the hull in 30 days, in full, without argument. The families waited 4 years and settled for 4 cents on the dollar. Then a court declared the company had never owed them anything. Did any of it hurt the company? It did not. White Star Line was the only company inside Morgan's entire trust that reliably made money across the decade that straddled the sinking. The accounts do not say whether it was in spite of the publicity or because of it. They only say that 1913, the first full year after the disaster, was the best year the trust had ever had. 3 sister ships were laid down in Belfast. The Olympic sailed for 24 years and earned. The Titanic sank on her first crossing. The Britannic sank in 1916 as a hospital ship, having never carried a paying passenger. 1 earning ship out of 3, and the line still made money. Both inquiries, Washington and London, pointed at the same missing piece. The regulation that governed lifeboats had been written in 1894. It required 16 boats for any British ship over 10,000 tons, and in 1894, there was no such thing as a ship 4 times that size. The Titanic carried 20. She was over the legal minimum by 4 boats, all the way down. Nobody had raised the minimum in 18 years. Nothing had gone wrong yet. The Olympic went into the yard in October 1912 and came out the following March. She came out with 64 lifeboats, a watertight inner skin along the boiler rooms, and 5 bulkheads carried up to B deck. Every one of those things had been available in 1911. And in January 1914, 13 countries signed the first Convention for the Safety of Life at Sea. 5 of them ratified it before the war arrived and stopped the whole thing. One piece of it survived, and it is the reason this story has not actually ended. The International Ice Patrol flies the North Atlantic every ice season. It is run by the United States Coast Guard, and it is paid for by the 17 countries whose ships use those waters, billed in proportion to the tonnage each one sends through. A season in 1994 cost $4,275,634. White Star never paid a penny of it. White Star was gone by then. The countries that sail those waters pay it still. Every April, an aircraft on that patrol drops a wreath over the position where she went down. In September 1912, 2 appraisers climbed into a lifeboat on a New York pier and priced what was left of the Titanic at $4,520. 4 years later, a court agreed the company should not have had to give even that. And the only bill from that night anybody still pays on time is the one for watching the ice.